So how much control can the government have over our lives, either from a tax standpoint or from other regulations and requirements? Those have been issues that have been decided in the Supreme Court this last session, particularly in the Loper Bright cases. And we have an expert here on the Wealthability Show with us today, Joe Bishop-Henchman, who has been with us before talking about more. Joe, great to have you back.
Great to be with you, Tom.
So, Joe, if you can, just for those who don't, who have not, weren't on the previous show, give us a little bit of your background, what you're doing right now.
Sure. I'm a lawyer at the National Taxpayers Union. We're based in Washington, D.C., and we make sure the taxpayer's voice is represented at all levels of government, everything from state legislative hearings to the federal and state courts to the halls of Congress. We're there to make sure that while those halls are filled with lobbyists fighting for the short term and for special interests, that somebody there is working for the long term and the general interest for all taxpayers. So that's what we do.
Well, we need you. So thank you for doing that.
Sure.
I think Congress has an insatiable appetite, and it used to be that one party had a bigger appetite than the other, but I'm not sure that's true anymore. So protecting the taxpayers' interests is really appreciated from those of us who work in the tax industry, especially. And but let's talk about these two cases as they relate to the average business owner. That's really what I want to get to. And let's start with the Moore case, because that's the one we addressed previously. And then we'll get to Loper Bright, which overturned the Chevron doctrine. I'm guessing people are going, what's a Chevron doctrine? I have no idea what that is. What was that case? And we'll get to that. And Moore is the case where, just to remind everybody, Moore is the case where the couple in the U.S. had an ownership interest in an Indian company, and it was a C corporation, so it was a regular corporation, and because of the 2017 tax law, they were required to pay tax, even though the money wasn't redistributed to them. And the Ninth Circuit took a very broad view of what Congress can do and ruled against the Moores. And the Supreme Court took a very different approach to it. So if you can, Joe, just kind of walk us through kind of what the Supreme Court decision said, why they said it, and then we'll talk about what they didn't say.
Yeah, that's a good one. So on the actual decision of the issue at hand in the case, they held that the mandatory repatriation tax from the 2017 tax law is constitutional and can be applied to this couple that invested in an Indian company. That's not really why everybody was interested in the case, though. That outcome, I think, was fairly predictable. I think it was unlikely that the Supreme Court was going to overturn the Tax Cuts and Jobs Act or a big provision of it, although that was there was a lot of briefs submitted urging the court not to do that if they were going in that direction. A big reason why everybody was focused on this case was because it was viewed as a proxy for the question of whether a wealth tax would be constitutional. And if you read the Wall Street Journal's op-eds or editorials on this case, you would think it was about a wealth tax case. Don't worry, there is no federal wealth tax or even a state level wealth tax yet, although proponents and opponents were looking at this case to see how the Supreme Court might think about that question. And the reason it came up is the couple in this case argued that their income wasn't really income because they hadn't realized it. So they had invested in this Indian company. The Indian company had been profitable and had retained earnings and reinvested earnings, but had never paid out dividends to the couple. And so they argued that because the money had never been paid out to them, it hadn't been realized, and therefore it wasn't income, and it was unconstitutional to tax them. So that's a bit of the background.
All right. So that's what was argued. So yeah. The court took I thought a very narrow approach to this. And can you just kind of walk through what that decision was? Basically, how did they rule against Moore, and how did they justify that it was okay?
Sure. So the court ruled that this was really about taxation of business income. It wasn't really about taxation of individual income. And this business did realize income. It did, sell things, earn profits, bring in money. And in taxing the business via this couple, they were the word the court used was attributing the income of the company to the individual. And they said, the question of whether Congress can do this is an interesting one. But Congress has done it for a long time. Subpart F has been around since the 1960s. There's a lot of other elements in the code where attribution of a company to an individual happens. Anybody that owns an LLC or a S corporation is familiar with that setup where you're paying your taxes on your individual code and your individual return mixed with your individual income. And they said, faced with this is the court speaking, the challengers had two options. They could either argue that all of that is unconstitutional, or they could argue that there's something different about this new mandatory repatriation tax compared with all the other stuff. And the court pointed out that the challengers took that latter approach, that second approach. They were trying to argue that there's something different here. And the court said, there's not really. This is pretty much matches what Congress has done in the past in other instances. So because nobody here is arguing that all of that is unconstitutional, we really don't have a choice but to say that it's constitutional. Which is kind of funny because some eagle-eyed people, including Justice Thomas, who dissented, point out that that really is not answering the question that the court said that they were going to answer when they took the case.
Well, that's my next question.
Yeah.
Why then, if this is the answer, why then did the court take the case in the first place? Because it's a very narrow solution, and why would they even need to go there?
Yeah. The question the court asked was, is taxation of unrealized income constitutional under the taxing power and the 16th Amendment? And they didn't answer that question. In fact, they specifically said in the majority decision that they're not answering the question. Although if you count up different justices, you realize that they kind of did answer the question. I can talk about that in a moment. But why they took the case is a very good question. It's something I've talked about with a lot of other tax lawyers and people in the field because nobody really predicted that they were going to take the case. It seemed pretty open and shut as far as where the precedents would lead. The speculation that I've heard, which I think I find most persuasive, is the Ninth Circuit, the court below, really produced an atrocious opinion. And because in their opinion, they said, well, Congress can basically do whatever it wants when it comes to taxes. And so the speculation is that, well, the court knew that was wrong and they didn't want that opinion to hang out there. And so that motivated them to take the case and kind of urge them to produce an opinion. I also might say that another reason why I think they took the case and then later on issued a very narrow opinion that didn't really answer the question that they said they were going to answer is this case, once you looked under the hood, I think was more problematic than maybe some people made it out to be. Some people said, oh, this is clean. You can just strike down. If you strike down this thing, then it'll foreclose a wealth tax forever. I think a wealth tax is unconstitutional. It's what we wrote in our brief in the case. But it was going to be a tough call to get the court to reach that result by striking down a key part of the Tax Cuts and Jobs Act that brought in, I think it's like $700 billion.
Right.
I wish, sometimes people talk about how the Supreme Court only focuses on the decisions and, let the chips fall where they may. But, they do pay attention to some things, and some justices, I think Chief Justice Roberts and Justice Barrett in particular are concerned about practical effects of the decisions that they hand down, and that may cause them to stop short of big decisions like this. So, that and I do have to note, we're just guessing. We don't know why they took the case.
Right.
Only the justices themselves know why they took the case.
Well, I for one, am glad they shut down the Ninth Circuit. So
Yeah.
I thought that ruling was way over the top. So Senator Warren has expressed that she believes that this opens the door for a wealth tax. And in Biden's budget this year, he actually uses an alternative minimum tax as a substitute for a wealth tax. So can you talk about that a little bit, Joe? And is there a workaround now to a wealth tax where it's not quote unquote a wealth tax, but it's an income tax? It's a wealth tax under the guise of an income tax. Did they open the door for that?
Yeah, it's a good question. They didn't close the door completely. And so that I'll certainly admit is part of this case. However, if you add up the different, because there's different opinions by different justices, and you add them all up, it's hard to count a majority in favor of the proposition that taxing unrealized gains is constitutional. And that's generally viewed as the workaround that might be most politically viable. France has their wealth tax, or had their wealth tax, which is you fill out a return every year and you add up it all and you multiply it by a percentage. Maybe Bernie or Elizabeth Warren is in favor of that, but for the most part, what the Biden administration and other kind of prominent politicians have put forward is taxation of unrealized gains. So your paper return in the stock market, or maybe other assets, I don't know, housing or something else, you have this paper gain, but it's not taxed until it's realized, usually until you sell the asset and then can subtract the basis. So the idea that we see from a lot of them is, well, let's just tax the unrealized gain each year. They get a little quiet when you ask about, well, what about unrealized losses?
Exactly.
A refund on that. I think the idea on that is you just get a carry forward that you can apply for future years there. So, not exactly a level playing field there.
So are there cases where we tax unrealized gains, right? We have market to market rules and
Right.
so forth. So how are those?
And that's a big reason why Senator Warren and some others think that this would be constitutional, because there are things you can point to that are similar to what they're envisioning.
So clearly, I mean, a huge issue if the Democrats are recapture the three the two houses of Congress and the presidency this year, then clearly this is something, in my mind, clearly something they're going to promote as a way to raise revenue to give to other programs that they want. What I think it's unconstitutional, but how do you deal? So how do you deal with this idea that, wait a minute, you do have some aspects of this where you are taxed on unrealized income. There are things in the tax law already. How do you deal with this? Do those go away too? I mean, at the same time, what happens when this wealth tax gets proposed and then goes to court, and let's say the Supreme Court shuts it down? What happens?
Yeah, Justice Barrett, in her opinion, confronts that question, and she kind of goes through the examples of what's in the code and some of the previous cases that maybe could be read as being supportive of taxation of unrealized gains. And I think she in my opinion at least, very persuasively shows why you can distinguish some of those earlier precedents and some of those other things from what is being envisioned by a larger tax on unrealized gains. So, at the end of the day, in her opinion, she reaches the conclusion that it would be unconstitutional. And I think, we kind of never know where Chief Justice Roberts is on a tax decision until he writes the opinion. But if you count him in, I think there's a majority who just think off the bat that this would not be allowed by the Constitution. But it was not forthrightly stated in the majority opinion, so I think it's a question that will be saved for another day. But it makes it all the more important to pay attention to Supreme Court nominations, because I guess they don't ask them too often what their view is on the 16th Amendment and the taxing power.
I
But
wish they would.
it certainly is a salient question.
Right. And so just for all of our listeners and viewers, this is a lot of money we're talking about. This is a big deal in France. It drove out a lot of their wealthy people, frankly. They're proposing it again. They're re-proposing it, or some people in the French government, the newly formed French government, are proposing it again. So, and of course, they have a different system than we do, because their system is you're taxed because you're in the country, not because you're a citizen of the country, where we're taxed because you're a citizen of the country, no matter where you live. So running away doesn't help you in from the U.S. standpoint. So there is a difference there. It would be harder to get away from in the U.S. if it were enacted. But let's now turn, Joe, if we could, to the Chevron doctrine. So, because this is a doctrine that, this was a court case, Chevron, that I believe is a 1984.
That sounds right, yeah.
84 case,
So back
I believe.
then, we had, if we're going to be crude on some of the political history here, you had the Reagan administration that just came in,
Yep.
And had a lot of agency heads that wanted to pare back regulations, and they were stuck because they couldn't get courts, which were primarily at that time dominated by left-wing judges, to let agencies do what they wanted in rolling back regulations. And so the Chevron decision of the 1980s at the time was viewed as a kind of Republican victory, because it said that judges had to defer to agencies on the interpretation of ambiguous statutes. So it's a long sentence. It's Congress passes a law, and sometimes they very clearly delegate something. So like the Clean Water Act delegates to the EPA to define what clean water is and issue regulations to achieve it. Pretty clear, although some people will disagree on that one, even that one. But Congress at least said what they wanted to be done. There are other statutes and other laws where Congress is not so clear, and the agency will say, "Well, we read from this that we have the power to do things," and they start doing them. And one example would be the student loan relief that we've been talking about for the last couple of years, where there is a federal law, which allows the Secretary of Education to waive student loans in individual cases of hardship. And they're taking that provision and doing these broad sweeping forgivenesses for entire classes and categories of people. And, the question is that what Congress meant by that statute? Is that the proper exercise of agency authority under that? And under Chevron, judges could not do an independent evaluation of that. They just had to take what the agency said at face value. And so we get these things where every time a presidential administration comes in, one of the first things the new president does is they sign a bunch of executive orders, and that's a bunch of things reversing the previous administration on agency interpretations.
Well, and
so we get these oscillations back and forth.
Right. And it's interesting here because the Chevron case, they wanted to get rid of regulations, and they weren't being allowed to get rid of them, where now we have a Biden administration wants to add regulations and expand regulations, and the taxpayer, sorry, not it wasn't a tax case, but
the vote. I always like talking about the facts. Those are always very interesting to people.
Yeah, let's take this case because now we have Donald Trump who is saying, well, look, we're gonna eviscerate basically the what he calls the deep state or the federal government, the bureaucrats, and we're going to take all these regulations away. So this case actually has a really big impact. And of course, it impacts every business owner because it impacts from tax. There's tax laws where the IRS has taken it upon themselves to to interpret laws, and what's the power of those regulations. And then there's the EPA, there's the SEC, there's the FTC. I mean, all of these administrative agencies have wielded a lot of power over the average business owner. So let's kind of take a look at this case and what did it do and what's going to be the result of it.
So this new Loper Bright case, which was handed down, it overturned Chevron. So that doctrine I talked about, where agencies get to automatically win in court, court judges have to defer to them. That doctrine is now gone. It's been overturned. And the case dealt with fishing boats. I guess fishing boats are required under a federal law to allow federal regulators to be on board to monitor the catch and to make sure they're not exceeding what they're licensed to catch and all of that. There's a National Marine Fisheries Agency. I didn't know it existed until this case, but that's what they do. The federal law laying this out says that for foreign boats, the foreign boats have to pay for the costs of the inspectors. For U.S. boats, the statute did not say who pays for that. And, I think obviously this was the issue, maybe not obviously, but this was the issue in the case is, well, what did Congress mean by that silence? Did they mean for tax dollars to pay for the U.S. inspectors or for the inspectors on the U.S. boats? Or did they mean for the agency to fill in that blank? Which is what the agency did. The agency filled in the blank and they said U.S. boats, just like foreign boats, have to pay the costs of their inspectors, which apparently it's a very high cost and a very big burden on especially some of the solo practitioner boats and the small boats. And so they challenged the agency's quote unquote interpretation of the law that in this case, and kind of got more than they ever asked for on the result. And the result was that Chevron is now overturned and judges have to make an independent determination on these statutes. You can't just defer, the court judges cannot just defer to the agency. And so what I talked about a moment ago of how every administration, you have these oscillations of agencies saying, well, we've looked at it and our conclusion is the statute mean X. And then the next party comes in the next term and says, well, we've looked at it and it means Y. And they go back and forth. That was brought up in the opinion by Justice Alito, who said, that can't be judicial interpretation. That's we should be interpreting what the answer is, not just letting each administration do whatever it wants. So now agencies have to think about what will be convincing to a judge. So, going back to your point on President Trump promising to come in, as all presidents previously have, and sign a bunch of executive orders on the first day, this decision may actually mean that he can't do that, or that it won't be as impactful as he thinks it does. It's a big change, a big sleeper case.
Yeah, let me ask you from a tax standpoint. So there are some tax laws where the Congress will say IRS shall write regulations to give the rules on this. And there are most tax laws where the Congress does not do that. And so how does that change the value of those regulations? I mean, clearly that's what the IRS is going to do, right? If they write a regulation, they're presumably going to be held to that. And if the taxpayer follows those regulations, the IRS isn't going to come after them. But what does it mean if you don't like that regulation, you don't like that rule? Does that mean that you're going to be able to win in court, or do you have to come up with some persuasive argument to win in court? Is it automatic that that's not the rule? How's that going to work for the average taxpayer who frankly could have a huge impact? Some of these regulations have enormous tax impacts on business owners. How are the judges going to view that?
Yeah, no, it's a very good question. Obviously, one that we at NTU, we work on taxes, how this impacts IRS and Treasury. It's a big question for us. It's important to know that there are Treasury regulations on certain things, but a lot of the other stuff that the IRS does is not regulatory. It's sub-regulatory. It's every time they do a letter or a revenue ruling or post a press release to the website, a lot of that stuff is sub-regulatory, and that's a lot of the work that they're doing to quote unquote interpret ambiguous or silent statutes. Before this case, all of that was pretty much guaranteed to be upheld in a court of law, even if it says crazy stuff. And that's good and that's bad. That's good, I think, for consistency reasons. We all, even if it's a bad interpretation, we know what the IRS position will be and what they're going to enforce. So that provides some certainty. But it's bad in that if it is a bad call, there's not really a way to challenge it. And so and I'll give an example of a regulation that is almost done, and maybe the first one where we're going to see what the IRS and Treasury's attitude towards this decision is. And it deals with an IRS practice where Congress passed a law that said if the IRS puts a penalty on a taxpayer, an IRS supervisor has to sign off on it before it goes to the taxpayer. Seems very simple. We worked for its enactment at NTU back in the 1990s when it was added, because there was lots of instances where you had these rogue agents, maybe not so rogue, but a lot of IRS agents who would throw on an excessive penalty on a taxpayer to motivate them to pay when the penalty really wasn't warranted. And so we wanted to make sure that it wasn't, it's not just anybody at the IRS can make this decision. You actually have to get someone to sign off on it. The IRS doesn't like this. They forget to do this in a lot of cases, so penalties keep getting thrown out in court. They've tried to get bills enacted in Congress to repeal the provision. We fought those efforts, so it's still in law. So now they've proposed a regulation. And what this regulation does is it defines supervisor as anyone who works at the IRS. So that's their end run around it, because the law says you need a supervisor needs to sign off on any penalty. So they're like, all right, well, we're going to have this definition of supervisor, which really doesn't make sense. But under Chevron, the judge cannot make an independent analysis of that. He just has to accept the interpretation of the agency. But under Loper Bright, the judge can now do that. So are they going to move forward with this regulation, or are they going to withdraw it or think about it in a different way? And that's the change in behavior I think some of the people pushing this lawsuit wanted to see, which is before, agencies can be like, well, let's push forward whatever we can get away with. And I'm not being partisan on this. I think Republican administrations have done this and Democratic administrations have done this. Whereas now the rule will be, well, what can we find? What will be persuasive to a judge? And, I get that in taxes, we may not see a lot of movement except on some of these edge cases like the supervisor approval, because, I've argued tax regulations to judges before. It's usually not judges' favorite things to argue about or to hear about. It's often very complicated, dealing with numbers. Most people do not go to law school because they're good with numbers, myself included. And so people, so generally judges really do want to listen to the experts if they have a persuasive argument. But if the argument is crazy or goes too far, such as saying supervisor is everyone that works at the IRS to get around the supervisor approval law, I think they'll have a hard time with that. So, it remains to be seen. This is a brand new case. We haven't really seen a lot of activity on it, I think. And it's not just the IRS, obviously. It's every federal agency is thinking about this stuff. And then at the state level, a lot of state judges have adopted similar doctrines. And so the question will be, do they follow the Supreme Court's lead in changing their view, which has happened in a couple states.
Oh, interesting. So really important cases here. It's important to understand, because we need to understand that the wealth tax really is still in play, and we're just going to have to wait and see. That the court did not resolve that issue in Loper Bright. Then this is one where I think this is a big deal. Well, while it might not affect you every day. At some point, it may affect you, whether it's like you said, EPA, whether it's FTC, whether it's the SEC. The SEC has been a little heavy-handed over the last few years, so it'll be interesting to see what happens there. And we're also already seeing court cases where the defendants are going after this, saying, "Well, wait a minute," or the plaintiffs, whichever side they're on, but they're going after this and they're saying, "Wait a minute, this is this was not congressional. This was administrative." And it's very much this battle that we have going on in the country right now between government and the average person. And I think I actually applaud the justices for this decision, because I think that it's just gotten over. We've gotten to this place of overburdensome regulations and too much of the IRS, I think, creating law, and Congress not doing their job. Frankly, I think in a lot of cases, it's Congress not doing their job, that they're not actually writing the law. They're not actually saying, here's what the law is. I've been reading, Joe, maybe you can comment on this just briefly, that tax is probably where they actually do a better job, that there are many other agencies where the agencies have much broader authority because Congress doesn't. The congressional committees don't have the level of expertise that they have, say, on the Joint Committee of Taxation on taxation. So it seems like, I don't know. I'd like your view. I mean, do you like the case? Do you like the decision? Do you think this is something that's positive going down the road?
I think the court got it right in both cases. And obviously that's not a unanimous view. There's dissents in both of these cases. I wish they had been more definitive on whether a wealth tax, that a wealth tax would be unconstitutional. I think that's the tea leaves in the case. But I guess hope springs eternal for Bernie Sanders and Elizabeth Warren and the rest of them.
Yeah.
But it's really hard to see that the founders in 1789, when they sat down and defined the words direct tax and indirect tax, and that they envisioned a federal government able to tax unrealized gains. But I guess that'll be a question for a different case. And similarly on Loper Bright, I think the court reached the right call. The way I view at it is it's about whether there's a thumb on the scale. So if the IRS makes some weird interpretation of a law, and I think they're wrong, and we're in front of a judge, the right answer seems to be that no one automatically wins. Right. Both sides can make their case, and the judge can make their best judgment based on the evidence that's brought before them. And I think in most cases, a lot of people talk about this as like, oh, we're not going to be deferring to the experts on the agencies anymore. If the experts do their homework, I think they'll still win in a lot of these cases. But it's really hard to see that, the experts under the Democratic administration say one thing, and the experts in the Republican administration say the opposite, and that this is really about expertise and not about partisan games in quite a few prominent cases. Tax, I think, has mostly been insulated from that. We don't really see a lot of IRS revenue rulings changing from one administration to the other. I certainly hope that never happens, and maybe this case will make sure that doesn't happen. We really ought to be getting at what the law is, and if Congress isn't doing the job, then we need to hold them more accountable to say what they want agencies doing.
No, that's absolutely for sure. Joe Bishop-Henchman, thank you very much for joining us from NTU, National Taxpayers Union. NTU.org is the website for more information about how NTU is protecting the interests of the taxpayers. Please go there, and there's lots of information there. Also at wealthability.com and other Wealthability shows. Remember, we actually looked at this early on. Later, we're going to take another look at what happens with this election coming up. And because we have a $7 trillion tax difference between the Republicans and the Democrats in in this election from what we can tell right now. So a lot of impacts on you and your business, on your pocketbook, on your wealth. And this is why we stay on top of this. This is why we're always bringing in experts like Joe, and always we need to stay on it, because if not, we can't anticipate it. We can't plan for it. And if we can plan for it and we can anticipate it, we're always going to make way more money and pay way less tax. We'll see y'all next time.
This podcast is a presentation of Rich Dad Media Network.